False Claims Act was enacted in 1863 at the height of the Civil War to address rampant fraud by dishonest government contractors who sold rancid food, shoddy uniforms, and infirm horses to the Union Army. The False Claims Act, or the FCA as it's commonly known, includes a unique qui tam mechanism to allow private individuals with knowledge of fraud against the government to bring a civil action to recoup damages and penalties for the United States. In 1986, once again in response to widespread reports of fraud in government programs, the FCA's qui tam mechanism was strengthened with significant bipartisan support. Since that time, the number of cases and the size of recoveries have grown exponentially. In 2012, a record-breaking number of qui tam False Claims Act cases, 630, were filed in federal courts around the country. These cases often involve damage claims for tens of millions, if not hundreds of millions of dollars against large corporate defendants. Many allege serious violations of the laws intended to protect the mission readiness of our troops, the health and safety of Medicare beneficiaries, and other important federal program objectives. The case law interpreting the statute is rapidly developing, and the statute has been significantly amended in the last several years, in large part in response to decisions from the United States Supreme Court and other federal courts. To help familiarize you with the legal issues and practice under the False Claims Act and issues likely to recur for the federal judiciary, we've put together a panel reflecting different perspectives on the False Claims Act and the qui tam process. My name is Colette Matsey. I'm with the law firm of Phillips & Cohen. We represent plaintiffs in FCA cases, and I'll be your moderator. Our panelists are the Honorable Catherine C. Blake of the District of Maryland, David Chisower of Goldberg Cohn, who also represents FCA plaintiffs, Michael Granston, the Director of the Department of Justice's Civil Fraud Section, and David Ogden of WilmerHale, who currently represents FCA defendants and was formerly Deputy Attorney General for the United States from 2009 to 2010. On behalf of all the panelists, we'd like to thank the Federal Judicial Center for the opportunity to present this program. After a bit of background information, we'll go on to discuss the initiation of a case, including its filing under seal, and the government's pivotal decision of whether or not to intervene and take over the case. We will also discuss some of the emerging legal issues in qui tam litigation and the role of the different parties, including the judicial role. A couple of housekeeping matters. When we discuss the FCA statute, you can find the full text of the statute on the program's page on FJC Online below the screen you're watching now. There is also a program outline listing the cases we will discuss. You can click on those links at any time during or after the program. Second, we welcome your questions. You can email them at any time during the discussion to fjclive@fjc.gov, and we will get to as many as we can in the last few minutes of the program. And finally, please do not forget to submit the online evaluation that is on the webpage. So let's get started. Turning first to Michael, can you give us a sense of the current use of the FCA?
Sure. Thank you, Colette. The False Claims Act has been accurately described by a leading treatise as the government's weapon of first choice in combating fraud involving federal programs that use federal funds. To give you a bit more insight into the importance of the Act in the government's fraud enforcement efforts, let me try to summarize those efforts at both a macro and a micro level. Let me begin with a macro view. In fiscal year 2012, the United States secured $5 billion in settlements and judgments under the False Claims Act, marking the third year in a row that the government's annual recoveries exceeded the $3 billion level. Of the $5 billion that the government recovered in fiscal year 2012, nearly $3 billion were recovered in healthcare fraud cases, representing about 60% of the government's total recoveries during that year. Since 1986, when the amendments were enacted, the government has recovered more than $39 billion under the False Claims Act. And of this amount, nearly 67%, or $26 billion, were recovered in healthcare fraud matters. Another $7 billion was recovered in procurement fraud matters. Qui Tam cases have also played a major role in the government's recoveries. In fiscal year 2012, the government recovered more than $3 billion, or 60% in such cases. And since 1986, of the $39 billion recovered by the government, more than $27 billion, or approximately 70%, was recovered in Qui Tam cases. As you noted, in fiscal year 2012 alone, the government received 630 new Qui Tam filings, and the number of new Qui Tam filings in the most recent fiscal year is likely to exceed 750. At a more micro level, let me briefly describe a variety of the types of cases that we have recently been pursuing under the False Claims Act. In the healthcare fraud area, we've pursued allegations against a major pharmaceutical company for manufacturing and distributing adulterated drugs, and we pursued claims against a company that performed unnecessary dental surgeries and other procedures on children. In the area of procurement fraud, we've pursued government contractors that provided defective flares to the Army and defective bulletproof vests to local law enforcement officers. Beyond these more traditional areas, we've also pursued claims against banks that violated federal lending standards, against for-profit universities that made misrepresentations to students, and we've pursued claims against oil companies for underreporting royalties due on oil and gas removed from federal lands. As these figures and examples indicate, the False Claims Act continues to play a very significant role in protecting all manner of federal programs and funds from those who would seek to defraud them.
Thank you. David Chiswell, there have been several challenges to the constitutionality of the Qui Tam provisions. Can you describe those to us?
Sure. Actually, one fundamental question is whether Article 3 of the Constitution can actually confer standing on a private plaintiff who is suing to redress an injury that's suffered only by the government and not by the private plaintiff himself. So the answer to that question is decidedly yes. The Supreme Court, in its decision in Vermont Agency National Resources versus the United States ex rel. Stevens, held that the private plaintiff is actually a assignee, a partial assignee of the government's claim, and on that basis has standing to sue. Vermont was a 7-2 decision, although all 9 justices agreed on the constitutionality issue. There have also been other constitutional challenges, mostly under Article 2, both under the Appointments Clause, claiming that a private plaintiff is not duly appointed to pursue claims of the government, and also under the Take Care Clause, where the argument is that only a member of the executive branch and not a private plaintiff can take care or enforce the laws of the United States. Those challenges have all been soundly rejected by various courts of appeals. And in fact, a summary of those courts of appeals decisions is contained in the 10th Circuit's decision in Stone, or United States ex rel. Stone v. Rockwell, which is part of the materials.
Thank you. David Ogden, what unique issues do Qui Tam cases pose for defendants?
Well, really, Qui Tam cases are unique for all parties concerned, the government, the relator, and the defendants, because it allows, the False Claims Act allows for and incentivizes private parties to bring suits on behalf of the government, creating an unusual 3-sided form of litigation in which the relator and the government join together adverse to the defendant, while sometimes, in some cases, contending between themselves for control of the case and the division of the recoveries. This triangular character of False Claims Act litigation we'll be talking about in a number of different contexts is virtually unique and gives rise to some of the most challenging legal issues under the Act and some of the most challenging practical issues. Let me identify 2 areas where this plays out, which we'll develop today. First, the seal period. Unlike other litigation, the defendant in a Qui Tam case does not get to see the complaint when it's filed. Only the real party in interest, the government, gets to see it right away. The government then initially gets 60 days to undertake an investigation of the relator's allegations, subject to court-approved extensions. Typically, in this period, the relator wants the government to intervene. The relator will retain a large stake of the recovery in any event, and will have the resources and the prestige of the Department of Justice behind him or her in seeking their bounty. Most, though not all, intervened cases result in substantial settlements, and most, though not all, non-intervened cases are dismissed or abandoned. So the relator will certainly try to persuade the government to intervene in this critical period. Typically in the seal period, the government will find occasion to seek information from the defendant through the use of civil investigative demands or other methods. And this decision about whether the government's going to intervene is critical for the defendant just as it is for the relator and for the reciprocal reasons. So the defendant will want to persuade the government that the case does not merit the filing of charges or intervention. And the reality is that if the government intervenes, for many defendants, it's simply going to be game over. They're going to be compelled to settle, even if they think they have strong defenses, because the potential penalties are so severe they really need to reach a resolution. From the government's perspective, they have a limited set of resources to investigate cases they were obligated to investigate. As you mentioned, more and more cases get filed, and so they may feel they need a longer seal period. Defendants may want more time to persuade the government of their position, while relators may want a favorable decision as quickly as possible. After the seal, the FCA creates unique challenges for management of the case and unique legal issues. If the government intervenes, it takes over control, but how does that translate into day-to-day operation vis-a-vis relators? And as mentioned, the penalties authorized are extraordinary, and so it raises questions as to whether regulatory violations, and if so, which kind, should give rise to False Claims Act cases. So there are special challenges for judges that come from all of these things, and Judge Blake, I think, will talk about those.
Judge Blake, what questions arise for you in overseeing qui tam cases that may be different from regular civil litigation or even affirmative civil enforcement?
Sure, there are a number, as the panelists have already started to tell us, and I just want to say I'm here. I'm looking forward to learning from the experts, which is everyone else on this panel. As a district judge, of course, I've had my share of False Claims Act litigation, and since there is such a multiplicity of litigation, I tend to learn what I need to know for a case, and sometimes I forget it the next day. But this has been a great learning experience, and will continue to be during the afternoon's conversation. What I'm looking forward to hearing about and talking about in terms of issues that are of interest in particular to judges in handling these cases are some of the practical and procedural concerns that we have, as well as, of course, the substantive, particularly changes in the law. And I'm hoping that the panelists will be telling us some of the behind-the-scenes strategy, if you will, the negotiations that go on among counsel and their clients, the concerns, as you've said, that the various players in this have. And what are the factors that each side hopes the court will pay attention to and will recognizing in ruling on some of the very important matters we have to consider, such as the length and the extent of the seal that is applied in the case, the decision to intervene, whether to dismiss a case, whether it's on a first to file or a public disclosure grounds, and what advice, if any, what might we get from the government on those issues. It's of course, I also want to be alerted to the significance of the recent amendments in the law, which I think will make a difference to some extent in how we approach some of these cases. The role of the judiciary is complex, I think, in overseeing this particular litigation, which itself is a kind of a hybrid form of both civil litigation and almost a law enforcement function that the government has. But the interests of the relator and the public, as represented by the government, overlap, but do not always coincide. And then, of course, there's the defendant's interest to be covered as well. And as you'll hear, particularly in regard to materiality and the complexity of the case law regarding such matters as express and implied false certifications, the impact of the standard that the courts choose to apply in resolving these cases can have a very significant impact on extremely important government programs and contractors. So I'm looking forward to hearing about that in the conversation.
Thank you. Before turning to the procedure for filing an FCA action, it's important to have a basic understanding of what conduct gives rise to liability under the Act. False Claims Act liability arises from defrauding the government by making false or fraudulent claims for money or property. As such, it's a powerful but limited tool. It is not intended to redress all violations of law by federal program participants, or even to provide a cause of action for all false statements made to the United States. Instead, the FCA imposes liability for treble damages and civil penalties under the limited circumstances where a defendant knowingly presents or causes to be presented, in the words of the statute, for payment or approval, a false or fraudulent claim. So a classic false claim would be submission of an invoice where goods or services are not provided or not provided as specifies or otherwise not eligible for reimbursement. For example, a kickback tainted claim, as we're likely to discuss. No proof of damages is required to state a claim. So there are two important recurring issues in FCA liability. First was a claim presented to the United States or one of its agents that's payable by federal program funds. And secondly, did the defendant act knowingly? There's a broad definition for scienter under the statute, and then no specific intent to defraud is required, but also it is not a statute intended for mere negligence. So turning once again to Michael, can you tell us about the procedure for the Attorney General to initiate a civil action under the statute?
And actually, the False Claims Act provides two mechanisms for a False Claim Act case to be filed. The action may be either filed by the United States or the Attorney General on behalf of the United States, or, and this is what makes the False Claims Act so unique, a False Claims Act action may be filed by a private whistleblower on behalf of the United States. Section 3730A addresses the first mechanism. It provides that the Attorney General shall diligently investigate any potential violation of the Act and authorizes the Attorney General, in the event it finds a violation, to file a civil action under the False Claims Act. The second mechanism is addressed in Section 3730B. It provides that an action may be filed by a person in the name of the United States. That person is typically referred to as a relator, because through the mechanism of filing a quitam action, that individual relates to the government information about fraud. And in this sense, the quitam action really can be viewed as simply another mechanism by which fraud is brought to the government's attention to enable the government to begin an investigation of that allegation. Most cases these days are actually filed through that second mechanism, by the filing of a quitam action, rather than the filing of an action by the United States. This may well be, at least in part, because those who previously would have come to the government with their knowledge of fraud as an informant are now coming to the government in the form of a quitam filing. Whether the government learns of an allegation of fraud through an informant or through the filing of a quitam case, once it receives the allegation of fraud, it initiates an investigation. And if the government determines that the allegation should be pursued and is unable to settle it, then the government will either file a complaint under Section 3730A, or it will join in the quitam action under Section 3730B, depending upon how that allegation came to the government.
Okay. And David, can you give us a sense of how the decision to file, where to file, and the procedural mechanisms for filing a quitam case?
Sure. So Section 3730B2 instructs a relator, if they're going to file a case, they have to serve a copy of the complaint and a written disclosure of all the material evidence on the government. And the statute actually makes it sound like both those things are supposed to happen at the same time. But in fact, a relator is wise to make sure that before they file the complaint, they serve the written disclosure statement with all the material evidence on the government first. And that is to preserve their status as an original source, should that be relevant down the line. And we're going to talk about the relevance of an original source and public disclosure later on in the program. But once the relator makes that written disclosure, then they are safe to go ahead and file the complaint. And of course, the complaint is served on the Attorney General, and it's served on the local U.S. Attorney's office where the complaint's filed. And then critically, as everyone's mentioned, it's filed, as the statute says, in camera, or in other words, under seal. So it's never served on the defendant, and the defendant doesn't even know that the case has been filed. Of course, there's a decision to be made at the outset about where do you file the case. And a lot of these cases are filed against large public companies, and under the venue statute, Section 1391 of the Judiciary Act, you really have the option of filing the case in almost any one of the federal judicial districts throughout the country. So then there's strategy involved in terms of, out of those districts, where do you want to file the case? And it really comes down primarily to two main factors. One is the relator is considering, and their counsel's considering, which U.S. Attorney's Office. They want to investigate the case. So they're thinking about the relationships that they may have with the various U.S. Attorney's offices, what kind of trust exists there, how much they're going to be allowed to participate in the investigation once it's filed, how aggressive the office is, what kind of resources they have. So that's a critical decision right there. And then they'll also consider whether that the law in that particular circuit is going to be favorable to them, because although it's a federal law that's supposed to be applied uniformly, different circuits have different takes on critical elements of this statute, as we're going to discuss as we go along. So you're going to want to consider which particular issues may come up in your case and how the particular circuit is going to handle them. One last thing is that you obviously want to pick a venue that's going to stick to the extent it could be challenged by forum non-convenes. And interestingly enough, the few cases that deal with the forum non-convenes issue in the False Claims Act context say that while the government, if they intervene, is entitled to substantial deference on the choice of venue and choice of forum, the relator, even if they're pursuing the case on their own, is not entitled to any or alternatively very little deference, which doesn't make a lot of sense to me, actually, because particularly if the relator is going to go it alone without the benefit of the government, it would seem that they're a plaintiff like any other plaintiff and should have the deference, but at least a couple district court cases have said no.
So David, you mentioned these cases are filed under seal, and the Senate report in 1986 explained that the purpose of the seal was for the United States to decide whether to intervene and to prevent defendants from being tipped off during a government investigation. Some courts have also suggested the seal serves the purpose of protecting the reputation of the defendant during the pre-intervention phase. And I know that the federal judges are often, not often, but at times have been called upon to consider whether or not there's been a breach of that seal, since it's enforced through the court order. The seal itself has been challenged on constitutional grounds and has been found, at least in the Fourth Circuit, by Fourth Circuit decision in ACLU versus Holder, Fourth Circuit 2011 decision, to pass constitutional muster. The challenges in that case were both under the First Amendment, a right of free speech question for the relator, and a right of access to under the First Amendment to judicial records, and also under separation of powers grounds. And there the court found that the seal was constitutional because of the government's compelling interest to protect fraud investigations and the narrow tailoring, because there's judicial review, ongoing judicial review at any request from the United States to extend the seal. Michael, can you give us a sense of what happens during the investigation period for the government, and any insight you can give us into interactions with relator or defendant during that time?
Sure, and let me just add one point about the ACLU case, and that was to note that in the government's submission in that case, the government took a narrow view of the information that actually covered by the seal. It took the position that it's the existence of the Quitom case that is the subject of the seal and that is not to be disclosed while the seal is in place, but further took the position that the underlying allegations that are covered by the Quitom case were not covered by the seal, and the government or a defendant or a relator were free to disclose the underlying allegations without risking breaching the seal imposed in any particular case. With respect to what the government does during this pre-intervention investigative period, obviously the primary issue for the government is to investigate the relator's allegations, to be able to assess them, and ultimately to make a determination of whether it should intervene in the case and take over the litigation on its own behalf. The specific focus of the government's investigation is obviously going to vary depending upon the particular issues in the case, but in most cases the government's investigation is going to focus on the two critical issues that you'd identified earlier. Did the defendant submit a claim that was false, and did the defendant act knowingly if they did so? This may require the government to do a number of different things to answer those questions. It may require the government to hire experts. It may require the government to do statistical sampling. Often the government may need to review patient files or contractor files. And almost certainly the government's going to have to talk to witnesses in the government, in the defendant, maybe third-party witnesses with pertinent information about the allegations. To conduct this investigation, the government is going to use the standard tools of investigation that are available to the government. And among these are the Special False Claims Act subpoenas subpoenas that David Ogden mentioned recently, referred to as civil investigative demands. The False Claims Act allows the government to issue these civil investigative demands for answers to interrogatories, documents, and testimony. Before the government makes an intervention decision, it will typically also sit down with the defendant and give the defendant an opportunity to address the allegations, to hear the defendant's side, and if appropriate, to give the defendant an opportunity to discuss settlement. Particularly in times of tight resources like these, the department is going to make every effort to try to resolve a case before engaging in time-consuming and burdensome litigation, not only for the parties but also for the courts.
David Ogden, can you give us some sense of what a defendant's interaction might be with the government during this investigation or seal period?
Sure.
Yeah.
I mean, there are really two sort of basic states for defendants during the seal period. One is when the seal is fully in effect and the defendant hasn't been notified about the case and the government has not yet contacted it even to inquire about the allegations, is a period in which there's no interaction about the matter. This is a period that goes on for a while, puts the defendant at a disadvantage because the case is being developed, but the defendant's unaware of it, is not in a position to preserve its own information that may be exculpatory, or to seek to have the government preserve information which may be exculpatory. But that's a period of time that at some point is going to come to an end. The government, as Michael said, is going to, through civil investigative demands or otherwise, reach out to the defendant to try to develop its case, and at that point the defendant has a critical role because, as I mentioned earlier, the government's intervention decision is absolutely a pivotal moment in this case. If the government chooses to intervene, the defendant is very likely to feel compelled to settle the case. If the government doesn't, the defendant will feel probably relatively free to litigate aggressively in defending the allegations. So this moment is the moment that the defendant can come forward to the government and try to persuade the government that it should not intervene and potentially to settle. And there, it's an opportunity to provide information. If you know what the charges are and you're in a position to provide the information, you can come forward, be forthcoming, try to be helpful, and hopefully persuade the government both that you're making a fulsome, clean breast of the situation, and second, that the case is not worthy of intervention.
Right. And we might want to matter as a procedural matter. At times the government will seek a partial lift of the seal specifically to be able to share the complaint with defendant. David, can you tell us what the relator is doing during this period? Because it can sometimes stretch for quite some time.
Sure.
Yeah.
Obviously, the relator views it himself or herself on the same team as the government and agree that intervention is a pivotal decision. Obviously, the relator wants to convince the government to intervene, and not only because it's going to make it more probable that there's going to be a recovery, but also because the relator typically has really persevered and has had to show a lot of courage to bring this matter to the forefront, and they are really looking for the validation of the government through that intervention. They want to know that the government believes what they're saying, and not only that, but they believe it's important. So the relator, any good relator, is going to do whatever they possibly can to help the government during the investigation. And that can range from the relator's own personal time and also the resources of their law firm in terms of helping them identify the documents that are relevant, going through particular lingo and language that may be used by the defendant to help them know how to ask for certain documents, identify witnesses, actually locate or track down witnesses, let the government know which witnesses are likely to be friendly and which ones are likely to be hostile. Michael mentioned that the government may have to hire experts, sometimes through the help of counsel. They may even be able to work with the experts and, in fact, underwrite part or all of the cost of those experts.
So Judge Blake, during the seal period, I think for most judges, what you see first is often a motion to extend the seal supported by affidavits from the United States most of the time. Can you give us a sense of what's most helpful for you in considering these motions for extension of the seal?
Sure. Let me start by going back briefly to that same ACLU versus Holder case that was mentioned before, because I think actually the dissent in that case is quite helpful reading to understand a lot of the concern that a lot of courts, I think, are feeling now about the length of the seal in particular and how that interferes perhaps with the public's right of access to this information. That was a strong concern in the dissent in that case. So The length of time that the case should stay either completely or partially under seal is, of course, one of the first issues the court does have to face. And I'll just describe sort of the typical way that this initial period might be handled and talk about some of the competing concerns that I think we have to deal with and resolve in making these decisions. When the complaint's first assigned to us, of course, it's under seal. The 60-day period of the seal is automatic. So I suspect that most of us generally review the complaint to get an idea of the scope and the complexity, maybe to note whether the relator has counsel, and if so, is that someone that we believe is experienced with false claims filings? Or is this perhaps a pro se filer? We do have some pro se filers, and that may suggest that we need to give the case a little bit more early attention. And while certainly not always true, there may be less likelihood of government intervention and lengthy investigation. But after that, I think that most of us expect and relatively routinely approve at least the initial request from the government for an extension of time to make that intervention decision, and there's usually a corresponding extension of the time for the case to remain under seal. It's not unusual, given the complexity of many of these cases, I think, for the government to need more time to investigate than the 60 days that the statute permits. Now, of course, the government needs to show good cause, both for the continued sealing, if it's asking for that, and for the need for the investigation. As you mentioned, the primary method, I think, is to have affidavits from the government. Those affidavits may include the views of the relator as well. And sometimes a court will have even an ex parte, but on the record hearing with the government, and perhaps, again, even the relator or counsel participating, if the court wants to press more deeply into the justification, either for maintaining the seal or for delaying the intervention decision, or both. But from having looked at the case law and just conversations over the years with my colleagues, you will not be surprised to hear that different judges set different priorities on the management of these cases, and that affects the kind of showing that they expect from the government and their willingness to permit more time. There are a number of factors I think we all balance, even if we sometimes come out differently. But can the government show a genuine need for more investigative time? Have they been diligent in pursuing the evidence? Are there difficulties in obtaining or analyzing documents or in finding knowledgeable witnesses? Does the case involve a particularly complex regulatory system? Is it one where the impact of a government decision to intervene is perhaps going to be particularly significant to the industry or to the government program that's at issue? And then related, but not completely the same, even if the government does need more time for investigation, does it have to be under seal? The length of the seal and the length of the identification don't have to be identical. And again, some courts have shown particular concern for the public's right of access to information about this litigation. The good cause standard that we have to apply is sometimes hard to satisfy. As you mentioned, the 60-day period originally was justified so that the government could get a look at the case without tipping off the alleged wrongdoer. But the longer the investigation goes on, that justification becomes less valid. The defendant may know by this time through the subpoenas or even through a partial lifting of the seal. But the defendant may want the seal to be continued, again, so that they have a chance, perhaps before this hits the media, to persuade the government that they did not make a false claim. There's a little bit to this that hadn't been pointed out yet. And the relator may want it under seal for a longer time because that person may be putting themselves in some jeopardy with their employment. They may not want to come out and be identified, particularly before that intervention decision has been made. So we have to weigh all of these. Is the case getting close to settlement? There are judges who think, particularly at the settlement stage, the public ought to be aware and be involved. And then occasionally, perhaps less substantively, there may be people that worry about that case showing up on their 3-year-old list, on the CJRA list, and some courts deal with that with administrative closings, and some just try to move the case along and accept it as a 3-year-old case if there's a good reason for it. But there are a variety of approaches. It may partially depend on whether all of you agree, or if somebody actually raises an objection, and we'll have to look at it more carefully.
So, thank you. And Michael, this question of whether the seal should be coterminous with the government's investigation that Judge Blake raises. Can you address that from the Justice Department's, point of view, or your point of view? Yeah.
Sure, and to follow up on what Judge Blake indicated, the government's needs to keep the seal in place may not always be coextensive with the government's need to have adequate time to investigate. And in situations where the court may be concerned about unsealing the allegations because of public interest or for other reasons, I think one mechanism available to the courts is to lift the seal either in whole or in part while still permitting the government to investigate. I think from the government's perspective, the paramount concern is that it be provided adequate time to assess the relator's allegations and make an intervention decision. And that's for a couple reasons. More and more we are seeing relators who may be only serving a small function in a larger corporation may have a piece of the story about a fraudulent scheme, but don't have all of the surrounding details. I would also note that several recent appellate court decisions have underscored the point that a relator doesn't need to bring to the government a fully developed complaint that is ready to be filed. Rather, what the relator needs to do is bring enough information to the government to allow the government to begin an investigation. That means, in many circumstances, the government is going to have to conduct a subsequent extensive investigation to be able to assess the relator's allegations, and even more so in the current environment where many qui tam cases are complicated. They involve nationwide claims, or sometimes they involve multiple defendants. Now, we appreciate that this may result in the department asking courts for a number of different extension requests, and we appreciate that Congress provided a role to the courts to serve as the gatekeeper, and that it's our obligation to show the courts that we are diligently moving these cases along. We are trying to keep our requests to a minimum, and we're certainly trying to justify our requests. But we do, at the same time, believe that we have an obligation to adequately investigate wrongdoing, whether in the form of a qui tam case or otherwise, before we accuse any entity of wrongdoing. Moreover, the courts have made clear that we have to meet the particularity requirements of 9b before we file a complaint. And as I indicated earlier, a fulsome investigation may help resolve the matter sooner and thereby relieve both the courts and the parties of the burden of time-consuming litigation. So we have this competing challenge of, on the one hand, trying to respond to the concern of the courts that we were adequately moving these cases, but also responding to defendants' interests and the public interest in ensuring a robust and complete investigation. I think we are doing a good job. Our current time for making intervention decisions across all cases is about 11 months. And given in particular the very complex nature of many of the allegations we receive, I think on balance we're doing a pretty good job on that score.
So if the seal lifted and the defendant and the relator proceed with litigation, can you address, David Ogden, first, there's situations where that's helpful for the litigation to proceed, even though the government's investigation is ongoing, or is that of concern to defendants?
Well, the concept of a lifting of the seal with a stay of the litigation may have a lot of appeal in a number of circumstances. In particular, I think that it may allow the defendant to have the kind of information about the matter and potentially access to the tools of litigation that may help it protect its legitimate interests, including knowing what documents it needs to preserve and potentially seeking documents from the government. That's critically important. I think having the litigation go forward beyond that in a period where the government hasn't made a decision may not be the most useful context for a defendant. I think it's pretty important probably for everybody to have a sense of which kind of case we've got here. But I do think there could be circumstances where lifting the seal partially, certainly the partial lifting of the seal is an important thing to do, and I think conceivably and lifting it entirely and coupled with a stay so that there's daylight, but nevertheless the government has time to move. It just needs to be and to fully assess it. Can't emphasize enough how important that decision is as a practical matter. Huge dollar amounts are riding on this decision. It goes down a path probably toward settlement one way, probably toward litigation, very well toward dismissal the other way. Critically important that that decision be made right, and the government is facing, and this is, I feel this from my days as Assistant Attorney General, where I was working with Michael and his colleagues managing this program, and then as Deputy Attorney General, where we were looking at resource issues. You said at the outset, and Michael did, how many of these cases are getting filed more and more with these prospects of big rewards, and the department's obligated to investigate every one, without a big increase in resources. So time is sometimes needed, but sometimes daylight is helpful.
Well, given the strain on resources, David, can you address situations in which it may make sense for the relator to proceed even though the government's investigation is continuing and for the seal to be lifted?
Sure,
Yeah.
and just every time the government asks for an extension of the seal or an extension of the investigation, as it may be, they always come to the relator first and ask for their agreement. And the relators are very reluctant to publicly make a filing disagreeing or objecting to an extension of the seal. It can happen, but traditionally that won't happen. But regardless of what and they want to be on the same team as the government and want to support the government, and so typically they go along. But if you want to know what's happening behind the scenes, what relators are really thinking is a lot of it is going to depend on whether the relator and their counsel are prepared to go forward with the case in the event of a declination. If they're not prepared to go forward and litigate the case on their own in the event of a declination, they're secretly and publicly saying, hey, government, take as much time as you need. We want you to have, investigate as much as possible, because if the government feels like they don't have time to investigate enough, they're probably going to decline, and that's the end. However, if the relator and their counsel are prepared to go forward, at some point they're excited about the case and prepared to litigate it without the government, they at some point just want to get a decision one way or the other and be able to move forward on the case. Because if you think about it, when the relator files the case, they're often file the case on day one, looking back towards a period of 3 or 4 years in the past, maybe up to 6 years in the past, or more. And then combine that with a 2 to 3 year investigation sometimes longer, and then a decision by the government, and then litigation, and going to trial is another 2 or 3 years after that through a regular discovery period. You're now putting people on the stand and asking them to recall events that can be 10 years old. Extremely difficult proof problem, which is not good for anybody.
So it seems, given how it's hard to predict how a relator might feel about the seal being lifted or the consequences for defendants. So to the extent Judge Blake had raised the thought that judges could entertain the views at times, as well as the views of the Justice Department, some relators might be in a position where it is they're in jeopardy, as you said, if the seal's lifted. Others maybe think the government's had enough time and be ready to go. So it presents a lot of interesting. Judge Blake, can you also address what mechanisms are available when you're confronted with the question of whether to keep certain matters under seal beyond, the government will often ask for certain matters to remain under seal, certain filings to remain under seal.
Sure. Sure, and this has come up recently for a number of district courts. I think the government does make the decision to ask for a lifting of the seal, either partial or let's assume this is a complete lifting of the seal going forward, but they will still ask to keep under seal certain materials, for example, the affidavits, the proffers, the documents, whatever's been filed along the way to justify to the court the need for the extensions to begin with. And sometimes the defendant's counsel will object to that and will want to see what this information was. And I think we are looking at it somewhat the way we should be looking at what's the justification for the seal. Is this just a boilerplate request by the government? The government will typically say, well, we need to protect our sources, or we need to protect our investigative methods. Well, if you go and look at the affidavits, and the affidavits themselves were pretty bare bones and didn't reveal anything specific, you're inclined to say, no, we're just going to turn this all over. I mean, unless the government can show something pretty specific about compromising, again, a witness or an investigative technique. And of course, we'll balance that concern of the government against whatever the defendant has advanced to us as a reason. They may have a fairly persuasive reason why it might be relevant to one of the defenses they have in mind, that they want to see that additional information the government filed. So that's just something, again, we're balancing interests and looking at the specificity of the reasons that are presented on both sides.
And just to follow up, the challenge that the government has is, on the one hand, I think the courts are rightly asking that if we're going to be submitting requests for extension of time, we put in enough detail to justify why we're making that request. On the other hand, the government's concern is if it doesn't have the certainty that if it puts in specificity in its submissions to the court for extensions, that those at least critical critical piece of information that it doesn't want disclosed, and if it was merely investigating a case under 3730A rather than through a quitom mechanism, wouldn't be disclosed and available to the defendant, then it's caught perhaps between the rock and the hard place of, on the one hand, I want more time, and so I need to be specific. On the other hand, I'm concerned that whether or not this information will be disclosed at the end of the day. So I think at least a standard going forward that gave the government certainty that if it was more specific, at least any critical piece of information in that disclosure would be protected, would alleviate, I think, both the problem with the courts on the one hand of having to evaluate non-specific submissions, but giving the government the certainty on the other hand that those submissions will be protected to the extent necessary.
Interesting considerations. Okay, so after all this investigation and the communications between DOJ and the relator and the defendant, and perhaps it's been presented to the court for extensions, the statute provides in section 3730B4 that the government shall either proceed with the action, what we've been referring to as the pivotal decision of intervention, or notify the court that it declines to take over the action, in which case the person bringing the action shall have the right to conduct the action. And 3730B4 talks about the different procedural mechanisms that are available in that situation. Also, the court may permit the government to intervene at a later date upon a showing of good cause in 3730C3. So now we're going to turn to some of the emerging issues in quitam litigation, some of the sort of hot legal issues that some of which are dividing the courts of appeals and may even rise to the Supreme Court again in the near future. The first emerging area we've identified is the question of what makes a claim materially false. And the statute defines material, and this provision was added in 2009, though it's the provision that was the general and most jurisprudence had adopted by that point, a natural tendency to influence or be capable of influencing the payment or receipt of money or property. The statute does not define false or fraudulent. Michael, can you explain to us what the courts have been looking for in determining whether claims are materially false or fraudulent and therefore actionable under the statute?
I can certainly try. To answer your question, let me begin with the following example. Assume the government contracts with Company X and requests that Company X perform 3 tasks. First, that it build a tank that goes 100 miles per hour. Second, that it paint the tank green. And third, that it clean up any spilled paint in the process. Assume further that Company X fails to perform any of these requirements, but submits a request for payment to the government anyway. The government then sues Company X, alleging that its failure to comply with each of these different requirements independently constitutes violations of the False Claims Act. The first 2 grounds for falsity in that example, the failure to provide a tank that goes 100 miles per hour and a failure to paint the tank green, are what are often referred to by the courts as factually false claims, reflecting the fact that the falsity really goes to the character or nature of the good that the defendant provided. The last ground for falsity in my example, the defendant's failure to clean up the spilled paint, is often referred to as a legally false claim, reflecting the fact that it doesn't go to the defendant's failure to provide the requested good or service itself, but rather some other aspect of the defendant's bargain with the United States. Although nothing on the face of the False Claims Act refers to either factually or legally false claims or distinguishes between the two. Nonetheless, as a practical matter, many courts have imposed additional requirements for legally false claims to be actionable under the False Claims Act. And let me identify 2 areas in particular where that has been the case, in the areas of falsity and in the areas of materiality. With respect to the issue of falsity, in determining whether a legally false claim is false, a number of courts have required that there be a certification. And really the courts fall into arguably 3 different camps. First, there are some courts that have held that the defendant must have submitted an express false certification that it complied with the underlying provision at issue. In my example, the failure to clean up the spilled paint. While most of the courts of appeals have actually rejected the express false certification requirement, 2 courts of appeals, the 4th and the 5th circuits, have left that issue open. The majority of appellate courts have held that there is a certification requirement, but they've held that that requirement can be implied, and in particular, they've been willing to find such an implication in the defendant's act of submitting a claim for payment to the United States. This theory of legal falsity has often been referred to as implied certification liability. Finally, the First Circuit, in a fairly recent case called Blackstone, has rejected the requirement of a certification altogether. The Blackstone court reasoned that there is no difference between factually and legally false claims and held that the test is the same in all circumstances, namely whether the government received what it bargained for. As a practical matter, it's not clear to me that there is a wide gap between the implied certification approach and the First Circuit's approach. Arguably, in both of those cases, the question really boils down to whether the defendant submitted a claim for payment while it was in violation of a material aspect of its bargain with the government. That leads us to the second question that has been a source of debate and concern, namely, what is the test for determining when the defendant has submitted a claim that violates a material aspect of its bargain with the government? Colette, as you noted, in 2009, Congress added an express definition of materiality to the False Claims Act, and now materiality is defined as having a natural tendency or being capable of influencing the government's payment decision. Where a defendant fails to provide the requested good or service, again in my example, failing to provide a green tank that went 100 miles per hour, normally the courts have had fairly easy time determining that the defendant's failure was material. It's in the context, again, of legally false claims where the question of materiality has become more difficult and more challenging. And in answer to the question of when a legally false claim may be material, the courts have increasingly relied upon a condition of payment test. In other words, the question is whether the underlying provision, again, the failure to clean up the spilled paint in my example, can be considered a condition of payment. And the Sixth Circuit's decision in the MedQuest case is a good example of this increasing trend. In that case, the Sixth Circuit concluded that the physician supervision regulation at issue qualified as a condition of participation, but not a condition of payment, and therefore was not a basis for False Claims Act liability. The court's reliance on a condition of payment test raises the obvious question of when do you determine that a statute, regulation, or contract term is a condition of payment? And I think we're still at a stage where there are more questions than answers, but at least let me try to highlight a few of the key questions that I think the courts are going to have to grapple with. The first obvious question is, does a provision have to actually state that it's a condition of payment to qualify as a condition of payment? The Second Circuit, in a case called Mike's, suggested that the answer is yes, at least in certain healthcare fraud cases. But a number of other appellate courts, the D.C., First, and Ninth Circuits, have held that the answer is no. Second, what if a provision expressly states that is a condition of participation? Does that mean it also can't be a condition of payment and therefore is outside the scope of the False Claims Act? As I noted in the MedQuest case, the Sixth Circuit distinguished the physician supervision regulation as being a condition of participation rather than a condition of payment. But it also went on to hold that certain fundamental conditions of participation can also be conditions of payment, and therefore the conditions of payment and participation are not mutually exclusive. And finally, there's a question of whether or not a provision can qualify as a condition of payment if it authorizes the government but does not require the government to deny payment. To go back to my example, if the contract had provided that in the event Company X fails to clean up the spilled paint, the government can either deny payment to Company X or can require Company X to clean up the spilled paint, would that be a condition of payment? In a case called Onin out of the Eighth Circuit, the Eighth Circuit suggested that the existence of other agency remedies does not negate the existence of False Claims Act liability. And that seems in keeping with the definition of materiality, which holds that a provision is material so long as it was capable of influencing the government's payment decision. So as these questions highlight, the contours of what is a condition of payment continue to evolve, and I think is going to be one of the most significant questions that the courts are going to have to grapple with going forward.
So David Ogden, in counseling clients in these highly complex federal regulatory schemes, what's at play for defendants, or potential defendants, I guess we should say government contractors, in this question of whether they violate a condition of participation versus a condition of payment? And can you address some of the concerns that defendants might have?
Yes, I'd be happy to try to do that, Colette. You know, I think you put your finger on it there. You know, when you're counseling a government contractor, the goal is not to become a defendant or to do anything that would be worthy of liability or that would even cause you to be the subject of of suit. And I think what's challenging about the legal regime that Michael has so ably described is that it is not clear what regulatory requirements, statutory requirements, or contractual requirements are conditions of payment or are material ex ante. That becomes clear when the government decides that they're going to take the position that it was either a condition of payment or material, or when a judge decides that, it becomes shudderingly clear at that point. But the problem for counseling and for a defendant looking at or a company looking at its situation is that when it's trying to be compliant and focusing its compliance attention, unless it has a clear statement by the government as to what the conditions of payment are and what is material, it's got to have a very wide, cast a wide net. Now, if you had a company in Michael's example that provided a tank that went 100 miles an hour and was an absolutely beautiful shade of green, but the contract did not specify you must clean up the paint. The contract maybe said you'll comply with all regulations of all kinds, shapes, or descriptions, or says nothing about it. But it turns out that cleaning up the paint, the failure to clean up the paint, a few little specks here or there, violated an environmental regulation. Now the question is that violation material? Was compliance with that regulation a condition of payment? And my submission is, even if it's decided ex post that it was, the idea that you're going to apply treble damages plus the liquidated damages plus open up the qui tam statute and allow private individuals to bring that claim, potentially debar this company based on a condition the government could have said was a condition of payment but didn't, isn't fair and doesn't create a conducive environment for government contracting.
Well, picking up this idea of whether it's fair, implicit in the government contract costs must be this cleanup obligation. So can you address David, can you address the materiality? How such a statement?
Yeah, I mean, on the one hand, I share some of the concerns and sympathize with the issues that David is raising, although not to be flippant, but you could always advise your client, just don't make any knowing misrepresentations and you'll be okay whether they're conditions of payment or not. My take on the jurisprudence in this area is, putting aside what the parties know or don't know, it can be very difficult for the court to figure out whether something is related to payment or not. And so instead, what the courts will fall back on is the underlying conduct. And let me give you an example, picking up on Michael's excellent illustration of how this will happen. Take the promise that the defendant makes in Michael's case that they're going to clean up the paint. You could see that playing out in two different ways. Imagine in scenario one, the head of the company goes to the billing clerk and says, hey, did you submit the invoice to the government for our tank? And they say yes. And the head says, well, did we clean up all the paint? And the billing clerk says, no. And the head says, well, what do you mean? Why didn't we clean up all the paint? We were required to do that. And they said, oh, well, we scheduled it, and they kept getting delayed, and we have it scheduled. I assume it's going to get cleaned up, so I'm not really worried about it. So that's scenario one. Imagine scenario two, where the head of the company is telling everybody, hey, we've got the government coming by to see whether we cleaned up this paint or not. Carpet over all the spilled paint. Don't tell anybody that we spilled paint, but we're not going to clean it up. It's way too expensive. But don't tell anybody because we may not get paid. I don't know. So I would submit to you that in either those two cases are going to be decided differently. A court is much more likely going to be to impose liability in that latter situation where there's more egregious conduct. But the underlying conduct really doesn't affect the decision. It was either a condition of payment or it was related to payment or it wasn't. And so really those two situations should be decided in the same way. And when they're not, the law can get very confusing. I think that's why you see circuit splits. What could be splits are actually maybe just different underlying factual scenarios explaining the different outcomes.
Another way to think of the point that David's making is rather than exclude a whole category of cases by defining either falsity or materiality so broadly that you not only exclude the cases that legitimately should be excluded, you also exclude the cases that should legitimately be included. The question is, should you find a way to shift it to a more fact-specific, case-specific inquiry? And typically that can be the issue of knowledge. And cases like Hutchison and the SAIC decision out of the D.C. Circuit sort of suggested that that's where the focus ought to be, so that we don't have categorical statements about what is or is not false that excludes not only the situation where they couldn't schedule the cleanup of paint in time, but also the situation where they carpeted over the spilled paint, and focus on whether the defendant knowingly knew at least it was doing something wrong or not, so that we capture only the truly culpable defendants.
So, Judge Blake, some courts have held that these issues of materiality can be decided as a matter of law. Perhaps Rogan is the best example of that out of the Seventh Circuit, where you actually had a statute that denied reimbursement under for certain physician-hospital relationships, financial relationships. How do you address these questions, especially where you have situations where the government there may be authorization, in the words of Michael, authorization but not a requirement that the government official pay the claim?
Sure. Well, this question of materiality obviously is complicated, and the way it's going to be resolved is going to depend very much on the specific facts and the law of the particular case, and that may very well include what circuit you are in. I think there is a pretty general agreement now, as you've indicated, and of course the definition of materiality is in the statutory language. It's being the natural tendency to influence or capable of influencing that decision to pay the claim. Nonetheless, the materiality is a mixed question of law and fact, so there are different approaches that the cases have shown to resolving this. I think first, a court would look to see whether the answer can be found as a matter of law among the unambiguous, if they are unambiguous, statutes and regulations and contracts that govern the claim for payment, and perhaps it can be determined based on the language of those documents, those regulations or statutes, that it is not a condition of payment. And I think the MedQuest or Hobbs case from the Sixth Circuit that you mentioned, the court decided as a matter of law that a violation of this particular type would not naturally tend to influence the government's decision. Now, if the violation or false statement does appear to be one that could influence the government's decision, another issue that courts have addressed, and interestingly, what I might have thought would have been long settled, but it's still relatively recently debated. How do you judge that question of materiality? Is it an objective standard? Are we looking at the point of view of a reasonable, non-negligent, a diligent government official, or are we looking at the actual decision maker, or some sort of subjective? Is it going to make a difference if you call in the government official and they said, "Oh, I didn't pay any attention to that regulation"? Well, there are at least a couple of decisions. You mentioned Rogan from 2008, where the Seventh Circuit said it's an objective standard. It's got to be an objective standard. And there's a more recent Second Circuit case in Feldman, which had to do with an NIH grant, that said, no, it's a test that applies to a reasonable official, so you don't necessarily have to have the government official appear to testify or even take their testimony in connection with a summary judgment motion. But because it is a mixed question of law and fact, on the other hand, sometimes the jury winds up considering these rules and regulations. In the Feldman case, the jury went to trial, and the jury was allowed to consider the guidelines and the instructions from NIH that govern these grant applications and come to their own decision, and they decided that it was, in fact, material. Or it may be, if the contract is not clear, you get testimony from the people that were the parties to the contract in the ordinary way that we approach contract interpretation decisions. So there will be a variety of ways to go after it.
Thank you. So the FCA creates certain restrictions on qui tam cases that require dismissal of the cases even if the relator has meritorious allegations and may be able to assist the government with valuable information and resources. One example is what is known as the first to file bar. Under 3730B5, and the language is, when a person brings an action under the statute, no person other than the government may intervene or bring a related limited action based on the facts underlying the pending action. David Chiswer, can you give us some understanding of how and when first-to-file issues arise for relators and what some of the key issues are with the provision?
One of the most hotly contested issues recently in the False Claims Act arena is who was first to file. I think the reason for that is that with the ever-increasing number of cases that are being filed, it's not uncommon at all to see 3 or 4 cases filed against the same defendant on the same subject matter, but by several different relators. And of course, it's easy to determine who was first in time to file, as the complaints are all time and date stamped. But the trick is that what you may see, and particularly in the first file cases, are cases filed almost preemptively by a relator who may be an industry operative, but only has very generalized knowledge of some type of fraud that's going on in the industry, but they file a very bare bones complaint, maybe against a dozen industry participants, hoping to be, first to file against all of them, when really they don't have any inside information with respect to any of them, but just sort of generalized notion of fraud that might be going on. And maybe, 6 months, a year later, another case is filed maybe against one of those defendants, but this one is filed by an insider, maybe a high-level executive, who's able to lay out a fraudulent scheme in great detail, including emails and documents and meetings, the who, what, where, when, why of all of the fraud. Obviously, the government is much better served by that second filed case, and it makes their investigation a lot easier. However, the more bare-bones complaint still may be enough to have supposedly put the government on notice of the type of fraud, so they could at least begin an investigation. And any good defense counsel is going to come in when they're served with that second complaint and move to dismiss the better complaint under the first to file bar. And so the outcome of those that type of motion may well depend on what circuit you're in. There have been circuits have taken different views on what you need to file in order to become the, quote, first to file under the statute. In the Walborn decision in the Sixth Circuit, the court said that if your complaint does not meet the pleading requirements of 9b, then you cannot qualify as the first filed complaint. On the other hand, the D.C. Circuit, it says 9b is irrelevant. It's really the notice standard that I just articulated. So there would appear to be at least some circuit splits on that issue, although if you do look at the underlying facts, again, at the cases, there is a way to reconcile them, because in the Walborn case, the first filed case was really bare bones and not at all helpful to the government, whereas the D.C. Circuit case, the second filed case, didn't add very much, and it was clear that the first filed case was the proper one to pursue.
So it sounds like a number of these issues may be coming before the judiciary soon, particularly with multiple relators filing the sometimes on the same allegations. I'm going to move to the second well-known restriction on qui tam cases, is the public disclosure bar, which was originally enacted in the 1986 amendments as a limit on jurisdiction, federal jurisdiction over cases where information about allegations or transactions had been publicly disclosed in certain specified fora, news, federal audits, reports, news media specified, and where the plaintiff was not otherwise qualified to bring the action as an original source. That language was recently amended in 2010. Both the language of public disclosure was somewhat tightened up. The language of original source was changed significantly, and some cases right now are straddling the two pre-2010, since it's not retroactive. The Supreme Court dropped a footnote and recently a couple saying it's not a retroactive provision. The other thing that's interesting about the 2010 amendment is the change that it's made for the Justice Department to be able to weigh in. The language arguably is written in a way to suggest that it's no longer a jurisdictional concern, and that if the Justice Department opposes dismissal and can oppose dismissal in either an intervened or non-intervened action, that may be a dispositive position. So, Michael, can you explain to us the circumstances under which the Justice Department has so far, I think, filed an opposition to dismissal in one case, a non-intervened case, what the considerations are and the position the Justice Department's taking in those filings.
Sure. As you noted, the new amendments are not retroactive, so there are still relatively few cases that are governed by the new version of the public disclosure bar, and the government's opportunity to actually consider exercising its veto authority has come up even in a smaller segment of those cases. There is one case where the government did recently exercise its right to object to a public disclosure motion, and that is in a case called U.S. XRL Mazda versus Miami-Dade. In that case, a former employee of the Miami-Dade Transportation Department alleged that the entity was misusing grant funds provided by the U.S. Department of Transportation. The county in turn sought to dismiss the case, both on the merits and on public disclosure grounds, and in response, the government filed an objection to the defendant's public disclosure motion. The court concluded first that the public disclosure motion on its merits was not well founded because the relator was ultimately found to be an original source. But the court separately held that in light of the government's objection that it was required to deny the defendant's public disclosure motion in any event. Now, in its motion, the United States took the position that if it objects to a public disclosure motion under the new version of the bar, that the court is obligated to deny the government's motion. And the Mazda court appears to have agreed with that interpretation. In its decision, the court stated that when the United States objects, quote, the court's directive is clear. The defendant's motion to dismiss on this ground must be denied. Now, while it happens that in the Mazda court, the court found that the public disclosure bar did not apply, I see no reason to assume that the government's future exercise of its veto authority will be limited to such situations. Indeed, it is not unreasonable to view Congress's rationale for putting the veto authority into the new version of the bar as a mechanism for the government to allow cases to proceed that otherwise would not be allowed to proceed because they would be barred. So I think one can anticipate that going forward, the department's decision as to whether to exercise its authority may focus more on whether the public interest is served by the case being allowed to survive, rather than whether or not the case would meet the technical terms of the public disclosure bar.
Right. And so, Judge Blake, for you, that raises potentially some interesting separation of powers issues, maybe. I mean, it's an interesting position where the executive is filing something saying this motion shall not be granted. Do you want to comment on that? Yeah.
Sure, it is an interesting situation. I want to go back very briefly on the first to file issue and just say, because I think one other thing for district courts to keep in mind, assuming that we are about to dismiss a case because the first filed case was sufficient and is still pending, we need to look very carefully about whether that dismissal is without prejudice, because it may be that even though that first filed case is there and it's pending, that will be dismissed or abandoned in some way. So the case in front of us could later come back. So I just wanted to mention that. This new position or authority given to the government will be interesting to see how it plays out. It is certainly the court that's been referred to took the position that it was an automatic decision. You really couldn't challenge the government on that, and that certainly would seem to be what the statutory language appears to be. Question whether courts will at least feel that they're entitled to ask why, what the basis of the government's position is. And I would assume that it might be that they agree with the substance of the legal position, but it might be, as you mentioned, the public interest of that particular forum, that particular relator, the way that case is positioned. You feel that it's in the public interest to go forward in that forum, and in that way, it may be that it's somewhat consistent with the take care clause in the Constitution, or the prerogative that's usually given to the executive in somewhat similar issues, such as whether to prosecute, where to prosecute, subject to venue rules, but in a criminal case. So I think, again, it will just have to see whether we challenge the government a bit or ask for an articulation of the reasons. The other change you mentioned is also quite interesting. It used to be a jurisdictional bar. The public disclosure was a jurisdictional bar. We approach it, therefore, under 12b1, and the burden's on the plaintiff and then we can consider evidence, and that's very different, or can be, from the way it's considered as a 12b6 motion, essentially an affirmative defense. So again, just something to keep an eye on for cases that fall after the 2010 date.
David, do you want to respond either to, the purpose of both the public disclosure bar and first to file are to ensure that new information is promptly reported to the United States. And can you explain the defendant's perspective on public disclosure?
Yeah, I mean, I think the purpose of both also are to provide an appropriate channeling for the use of what is an extraordinary exception to the general rule that parties may only assert legal interests that they start out with. The legal interest here is an interest of the United States, and as Michael and as David pointed out earlier, this statute creates an exception through a partial assignment as the legal concept. And the question as to who is an appropriate recipient of that assignment is critically important, because the consequences of allowing the suit to go forward are significant, not just for the defendant, but for the government, because the more lawsuits, the more you raise the general cost of doing business with the government. And at some extreme, that would become unacceptable. And so with the goal of, as quickly as possible, generating information for the government on which it can make a decision whether to proceed, information the government otherwise wouldn't have access to. These two rules, the first to file rule and the public disclosure bar, serve that key function. It's only those claims that bring new information to light that merit the provision of this extraordinary power to bring a claim that is not otherwise yours, and to allow claims that are already in the public domain to go forward and to allow people to pursue those would be to allow a potential proliferation of litigation that wouldn't be in anybody's long-term interest. So it makes good sense. I think if the government is now going to exercise this authority to make exceptions to that, I think it is important that the government develop some principles to use to mediate that, and to have there be consistency of some kind among cases, and potentially to allow defendants as well as relators to discuss these issues with them before they make that decision, particularly if it's going to have the effect of law in a matter.
Now I see thank you, David, we have a few questions from viewers. And the first one is that it has a bit of a lead in here. Recently we have seen government motions or requests or applications to partially unseal the complaint, to share it with defendants, and with any courts in which related proceedings may be ongoing. Sometimes this request is made with relators' knowledge and consent, but other times it is not. As far as I read it, the statute does not address this specific scenario, although the statute and its legislative history indicate that the purpose of the sealing period is to assist the government's investigation. Do you have any recommendations about how to deal with this scenario? Does it matter whether the relator consents or not, especially given that the government is not even a party to the action at the time the request is made? Who wants to take that one? Motions for partial unsealing.
Well,
Yes.
maybe let me jump in and certainly
Right.
welcome the thoughts of everybody else. I think the better practice would be and should be for the government to consult the relator and make a representation to the court. While I agree that I think the primary purpose of the seal is to put the government essentially in the same position it would be if it was investigating through some mechanism other than a qui tam case, which normally allows it to investigate and decide when it wants to disclose to the defendant. There are still collateral consequences to disclosing a case, whether it's to a defendant or another relator. And in that regard, the party to the case, namely the relator, I think should have an opportunity to be consulted and have input to the court if it ultimately disagrees with the partial unsealing. So the question of whether the relator should be consulted, to me, is separate from the merits of ultimately whether a partial lift seal should be granted. But I think the better practice would be to allow the relator input into that question.
By the same token, it sounds like one of the issues there is there may be another proceeding going on.
Yes.
And the truth is, the seal is mostly to protect the government. The relator may have filed another case, maybe just related to their own employment situation, and then maybe getting a question in an interrogatory or in a deposition in that matter, what actions have you filed against the defendant? And they can't answer that question without violating the seal, which is why really it's not a good idea for relators to if they can avoid it, to be filing those actions separate from the qui tam case, because they then may be asking now for a partial lift of the seal so they can inform the defendant and answer that question honestly. But then that really isn't taking into account the interests of the government and having it remain confidential during the seal. So while it is a good practice to ask the relator, I think the relator also needs a reciprocal duty to the government to try and protect the seal if necessary, when necessary.
Mm-hmm. Yeah. We have a similar question here that I understand that occasionally the government will move the court to partially unseal the relator's complaint. There was some discussion of policy considerations, for example, facilitation of settlement, that might motivate a court to grant the government's request for that relief. These considerations aside, does the statute authorize or contemplate a court order that the complaint be partially unsealed, that it be shared with defendants, or as is frequently the case in the first to file context, sometimes with other relators?
I think that it certainly has been permitted under the statutory scheme, and there are many good reasons for it, as we discussed a little bit earlier. The partial lift of the seal, it seems to me, would be subject to the same good cause standard that generally is applicable under the statute. That's what the court would have to look at in considering whether to partially, as compared to completely, lift the seal, or looking at it another way, whether to partially or completely extend the seal. Is there good cause to extend it in part, but not in whole? And I think it is a very legitimate concern to give the government the chance to present the complaint to the defendant and begin that process, that dialogue that, as has been explained, is, I think, of critical importance to all parties in the case.
Right, and I know often we, stepping on a moderator role for a second, will often ask the Justice Department in those circumstances, will they redact the name of the relator? And sometimes have sought a court order to that effect, though usually it can be done voluntarily. And sometimes it can be more helpful for the relator to be known to the defendant so they know exactly what kind of information, but there is sometimes. The other thing we should, along those lines, mention is that, of course, the False Claims Act does also provide, in 31 U.S.C. Section 3730H, a cause of action for alleged retaliation. And so that's another important safeguard that Congress included.
And so I do think,
yeah, go
just
ahead.
on those 2 points,
Yes.
I do think that it may be quite relevant in providing information that will be important to the government for the defendant to know the identity of the relator, and there are other kinds of protections that courts can fashion in those circumstances. Similarly, I'm not sure I can come up with it sitting here, but I can imagine that there might be good cause, notwithstanding the best practices that Michael identified, and I would agree generally the relator should be brought into the picture on the question of a partial seal and have his or her opinion sought. But I suppose I can imagine circumstances in which it would be in the best interest of the government in sorting this through not to provide that information to the relator, and in such circumstances I'm not sure anything in the statute would stand in the way of that if a court were persuaded of that.
Mm-hmm. So another question we have is to explain the difference between a public disclosure, which may itself bar the case from going forward, versus government knowledge. To the extent the purpose of the statute is to ensure that the government has the opportunity to investigate allegations, it might seem that information that's in the possession of the government is sufficient to put it on notice. And public disclosure is just an added. So can you address that question, Michael? Does government knowledge, what's the difference between government knowledge and public disclosure?
Sure. I mean, typically, you're going to be talking about a temporal difference between the two, where a defendant alleges that the government knew and therefore it negates the defendant's scienter. We're talking about events that happen contemporaneously around or before the defendant's submission of the false claim. And therefore the argument is, I submitted the claim, I told the government what I was doing, the government didn't tell me, no, I shouldn't be doing this, and therefore I believed what I was doing was okay. Typically, the public disclosure is referring to an after-the-fact disclosure about the prior alleged fraud. And then the question is, now that the allegation of fraud has come after the fact, but before the quitam suit was filed to the government's attention, does the government really now need a relator to help it investigate those prior events, or is the government on sufficient notice that it should investigate that there's no added value to the quitam case? So I think the biggest difference, again, is this temporal difference of when the alleged knowledge or public disclosure has occurred.
David, do you want to address that?
Yeah, I would just say
Right.
government knowledge, just the mere fact that the government knows about the fraud, actually used to be a bar for the relator of even pursuing the case in the first place. But that bar was eliminated in 1986 with the amendments to the False Claims Act. So it is important to know that the knowledge that the government gets from a public disclosure requires more than just the actual existence of the knowledge. It does involve something public, like a media announcement or a federal public report.
Mm-hmm. Can you also address for us, in the new original source provision that was enacted in 2010, there are a couple of ways that one can qualify as an original source, including that you've voluntarily disclosed pre-filing and materially added to the information that's in the public domain.
Right.
How is that?
So the new original source provision cleared up actually one big issue, which is now it's clear that if you made your disclosure to the government before the public disclosure, you qualify for an original source right off the bat, and which makes sense because you're obviously then not the parasite that the public disclosure bar is designed to weed out. If you already gave the information to the government before there even was a public disclosure, you obviously weren't copying any public disclosure. But secondly, even if there is a public disclosure, if you are able to materially add to it by providing the government with information that makes their investigation significantly and substantially easier, then you can also qualify. The words materially add are new in the statute, and they really, although there's been a couple of district court cases decided under the materially add standard that haven't really fleshed out what that standard is yet.
Okay. So the role of the court continues throughout through settlement and award of relator's share. And the statute provides that the government may settle the action notwithstanding the objections of the person initiating the action if the court determines after a hearing that the proposed settlement is fair, adequate, and reasonable under all the circumstances. Michael, can you discuss what would happen if a relator would object to a settlement to which the government and defendant have agreed, and maybe the consequences for defendants as well?
Sure. I think there's both a procedural and a substantive question that arises in that circumstance. The procedural question is really, how does that issue get teed up for the court? And really, in practice, I've seen it teed up in one of two ways. Either the relator can file a formal objection to the court if they believe they've reached an impasse with the government and no further dialogue can resolve the dispute. Or sometimes the government will submit the settlement that it's reached with the defendant saying, we believe this case has now been resolved and we ask the court to dismiss it. And then the relator can interpose an objection to the dismissal and the settlement if the relator chooses to do so. The substantive question that arises, regardless of which path gets us to the point of the dispute being joined, is the settlement fair, adequate, and reasonable, and more importantly, what does that standard mean in the context of the False Claims Act? And I think there's really been sort of two views on that. One is that we ought to borrow from the meaning of that phrase from the class action context, and that's a fairly well-known standard to the courts, and among other reasons, that may be something that supports borrowing that standard. On the other hand, the government has argued that perhaps a more deferential standard is due because there are some differences between the False Claims Act context and the class action context. First of all, there's no unrepresented parties, as there often is in the class action context, so perhaps the need for the court to protect those individuals is not as strong in the False Claims Act context. And second of all, and obviously it's the government, not the relator, that's the victim, and so perhaps the government's assessment of the settlement should be given more weight than perhaps in the class action context.
Well, we're rapidly running out of time, so we hope you found the discussion useful, and please don't forget to submit your online evaluation. Once again, I would like to thank all of the panelists, and on behalf of the Federal Judicial Center and all of us False Claims Act practitioners, thank you for watching.